كلية الفقه الحنفي تقدم.
Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to lesson 5 now of Kitab al-Qisma. MashaAllah. I think we're learning quite a bit about this. So yesterday we had just ended with the discussion on somebody who claims to have not gotten and received his full portion. Puts in a claim for that after having said that he'd actually received it, and the discussion then was about whether his lawsuit will be accepted or not, whether he'll be accepted or not. Now there's a continuation of that discussion today that we're going to do, and a few other things that we'll be discussing. This one is a bit of a lengthy issue, and then that will pretty much end the chapter for us, and then we'll inshallah start the next chapter. So وَإِذَا قَالَ إِسْتَوْفَيْتُ حَقِّي, if he says that, if he had said that I have tried to get and I have actually attained all of my right, I've been able to receive all of my right, ثم قال أخذت بعضه, and then after that he says I only took a part of it, not all of it. So you can see there's a contradiction in his statements now. First he said I've received everything, and then he says, oh, I only took a part of it. So he's either deluded or he's lying or he's confused. So then it says فَالْقَوْلُ قَوْلُ خَصْمِهِ. In that case, since he's got so much tadad and so much contradiction in his statement, they're going to take his opponent's view. His opponent will be told to swear an oath, because this guy, remember, doesn't have any proof. If he had proof, then it could have been fine, but he doesn't have any proof. So his adversary, his opponent, his statement will be taken with his oath, لأنه يدعي عليه الغصب وهو منكر. Because it's almost like the claimant here is claiming and accusing the other person of usurping his right, inappropriating his right. And he has no proof for that, and the other person can get out of it by just swearing an oath. So it will be his opinion, because the default is that there should be no usurpation. Usurpation, inappropriation, is not the default status, right? That something is claiming, so you better prove it. As I said, you have to go back to the default when you have no evidence in these kind of cases. وإن قال أصابني في القسمة إلى موضع كذا فلم تسلمه إلي ولم يشهد قبل ذلك على نفسي بالاستيفاء وكذبه شريكه تحالف وفسخت القسمة. Now, completely different scenario, right? So we'll look at this different scenario in the next part, inshallah. Right. So if he said during the division this much was allotted to me, but my adversary here, he has not handed it over to me, he still has my portion. Okay, so similar to the previous one, except that in this case he hasn't given any testimony and has not declared that so in this case he hasn't declared that he has received anything, right? He never said before that I've got my right, like I fully received everything that was owed to me. He's never said that. This is just a fresh claim that, look, this much was allotted to me in the division, but I haven't received it. I haven't received it fully. Obviously his opponent is saying, I don't agree with you. Right, he's denying it, because had he not denied it, then he would have given it to him, right? So he wouldn't have had to go to court. In this case, saying he denies it. So there's no proof on either side. This first person hasn't been able to provide any proof, otherwise it would have been done deal, right? He's got no proof, and the difference is that he's not been able to, he hasn't said before that I fully received it. He didn't confess to that before. So this is a fresh case. So in this case, because there's no proof, they're saying that tahalafa, they'll both be made to swear their own oaths to try to determine if one of them is wrong. So if any of them refuse to swear an oath, then it means that they're probably at fault or they are guilty. If they both swear an oath, فُسِخَتِ الْقِسْمَةِ, this will lead to that whole transaction being cancelled. The division that had happened earlier will be cancelled, because their difference of opinion is with regards to the actual distribution itself. So it didn't work out for them. The other guy is refusing to say that that is my share. So person A is saying that this particular portion of land was given to me, or this room was also mine. And the other is saying, no, that's not right. So it's actually a difference of opinion, a conflict regarding the distribution itself, or whether the distribution was correct or not, right? So of course, if they have a record of the distribution, then that would be evidence, but they don't have a record either. فَإِنَّهُمَا قَدْ اخْتَلَفَ فِي قَدْرِ مَا حَصَلَ بِالْقِسْمَةِ. They are disputing over the amount that each one of them should have attained through the division itself. That they're both saying the division was different. فَأَشْبَهَ الْاِخْتِلَافَ فِي قَدْرِ الْمَبِيءِ. So this is very similar and resembles a dispute regarding a purchased product between two people. Oh, this is how much I purchase and this is how much you purchase, and there's a whole ikhtilaf about that. فَوَجَبَ التَّحَالُفُ. So that's why they both have to swear an oath to see if we can resolve it that way. Sharh al-Ispijabi mentions this. Now, there was a important clause which I pointed out already, that the clause in this one is that until now he hasn't claimed that I received everything. Because had he claimed that and then he changing his story, then there's going to be conflict in his statement. So that's an issue, right? لأنه لو سبق منه ذلك, because had he said that before, لا يتحالفان وإن صحت الدعوة. So even though his claim is still correct and valid, but they are not going to be made to swear an oath. But it's just going to be his bayyina now. Just can he provide evidence? And if he doesn't provide evidence, then it goes the normal way, because it's still a da'wah, remember? It's still a claim, it's still a lawsuit. So he gets to present evidence. If he doesn't have evidence, then the other side has to swear an oath to get rid of it. Then there's a whole discussion regarding that if you are treating this lawsuit as valid and his claim as valid, but you're not making them both swear an oath. So the da'wah seems to be valid because they allow the da'wah to continue, right? This is, whether he had made witness to the fact that he'd acquired everything before or not. So what's then the point of doing the mutual or oath swearing? Why do they make them do that in that one scenario, right? So that discussion takes place here. We're not going to go into that because that's just going into the ilm. We don't need to go into that right now. The next point then is وَإِذَا اسْتُحِقَّ بَعْضُ نَصِيبِ أَحَدِهِمَا بِعَيْنِهِ لَمْ تُفْسَخِ الْقِسْمَةُ عِنْدَ أَبِي حَنِيفَةَ وَمُحَمَّدٍ ويرجع بحصة ذلك المستحق من نصيب شريكه لأنه أمكن جبر حقه بالمثل فلا يصار إلى الفسخ. This is a case where you have a division of a shared property between the two partners, and they share it up. They've got their sections, they've got their portions, and then suddenly it turns out that the rightful owner of a portion of person A, of partner A's section, belongs to somebody else from before, right? Maybe it was an inheritance issue, and then it was discovered that the portion that came to inheritor A, a portion of that actually belongs to his uncle. They only realized, and it's definite that it belongs to the uncle. That means that if they were supposed to be 50-50 shareholders, that means this person is going to have maybe 25% less now, or 50% less, whereas the other gets his full portion. So what do you do in that case? Shall we just go ahead and cancel the whole division, start again, minus that portion that belonged to somebody else, or what should we do? So they say, no, you don't need to do that. There's another way to resolve this, which is, this is what he says. He says, when a portion of the share of one of them specifically becomes, it turns out to be an entitlement of someone else, the ownership of somebody else, they use the word istihqaq for that. Somebody else, it becomes somebody else's right. It's established as being somebody else's ownership. The division will not be cancelled according to Abu Hanifa and Imam Muhammad. The Tarafain, they say, no, don't cancel the whole thing. وَيَرْجِعُ بِحِصَّةِ ذَلِكَ الْمُسْتَحِقِ مِنْ نَصِيبِ شَرِيكِ. He just takes that much extra that he's lost. To make that up and make it fair, he just takes that much up from his partner's share. Because it's possible to mend this discrepancy, to correct this discrepancy by just taking a like amount. So that's why you don't need to go to a fasq. However, Imam Yusuf says, no, that's going to create some confusion. Okay, which part should I take, and so on and so forth. That could create a confusion because they couldn't. One of the reasons they had to divide, or actually they could have divided themselves. This doesn't have to be that somebody else divided for them. Even their own division is a division. So it could cause problems. Imam Yusuf says, no, the whole division of it, they have to start again. The one that they did becomes annulled and cancelled. لأنه تبين أن لها شريكا ثالثا. Why? Because technically speaking, and in reality, that means there's a third partner in that whole asset, which is that uncle, for example. وَلَوْ كَانَ كَذَلِكَ لَمْ تَصِحُ الْقِسْمَةِ. And had we known that from before, that there was a third person, then unless you sat somebody in his place and made a representative there, you could not make a division, because otherwise it's like you're making a judgment against a non-present person, right? So he goes back to that, right? Imam Abu Hanifa is saying you don't have to go that far back. We can just sort it out. In the Hidayah and Sharh al-Zahidi, the Musannif has mentioned this difference of opinion, and similarly is mentioned in the Asrar. However, he says that the sound opinion is that remember, the mas'ala here was a particular portion, like this room or this corner plot. If it was not like that, but it was like, oh, that person, that uncle is a shareholder, he's got a 25% shareholding or a 10% shareholding, that means now it's 10% in everything, in this share and that share maybe, or just in this part of the share maybe, right? So if it's more of a common ownership issue, where it's a spread ownership rather than of a particular area for sure, then he says that if there was a difference of opinion with regards to a more commonly owned share, right, that I owe 10% to him, so right, so this difference of opinion from Imam Abu Yusuf and versus Imam Muhammad and Imam Abu Hanifa is actually regarding a particular scenario, which is that only if it's to do with a spread portion rather than a particular portion in one of their sections, not in both sections, right? That was only if the third person's claim came out to be in a spread portion overall, 5%, 10%, whatever it was, rather than a specific area. وَأَمَّا فِي إِسْتِحْقَاقِ بَعْضٍ مُعَيَّنٍ لَا تُفْسَخِ الْقِسْمَةُ بِالْإِجْمَاعِ. So they're saying now that actually if it was regarding a very specific portion, that this room or these 5 square meters or whatever it is, then according to all of the Imams, madhabs, whatever, sorry, all of the, not madhabs, but Imam Abu Hanifa, Imam Yusuf, Imam Muhammad, all the 3 Imams, it's easy to deal with that one because that will go away, right? That section will go away, and then the person can just take that much extra from the other person. وَلَوْ أُسْتُحِقَّ بَعْضٌ شَاعِيٌ فِي الْكُلِّ. Now what happens if they both split their sections and then the third person, the brother of the father, right, turns out to be a shareholder in 20% of both of their land, so the land overall that they had split up? Then in that case, تُفْسَخُ بِالْإِتِّفَاقِ. All the Imams will say that in this case they're going to have to start again. So these are 3 scenarios, right? One is that the istihqaq, which means the entitlement of the third person, comes out to be only in one section, and that in a specific portion. in that case, they say that it doesn't have to be cancelled, you just take from the other section. The second scenario is that it's in one person's portion, but it's in a percentage overall rather than a specific section, right? And then the third option, which is this one, which is that it's entitlement in both of their lands. So in that case, they're gonna definitely have to do it again. وَلَمْ يَذْكُرْ قَوْلَ مُحَمَّدْ وَذَكَرَهُ أَبُو سُلَيْمَانَ. So according to this previous, I'm just going into depth here. This is what is mentioned in the Hidayah and Sharh al-Zahidi, etc. Okay, they don't. Sahib al-Quduri actually does not mention Imam Muhammad's view, right? Because if you look at his statement, he just says, وَقَالَ أَبُو يُوسُف تُفْسَخُ الْقِسْمَةِ, whereas he does mention in the Abi Hanifa Muhammad in the original case. So in some of the side cases, he doesn't mention Imam Muhammad's view, whereas, so it's only in the last scenario we're talking about, where he doesn't mention Imam Muhammad's case, opinion. Abu Sulaiman has related that Imam Muhammad is actually with Imam Yusuf. And Abu Hafs has related that Imam Muhammad's view is similar to Imam Abu Hanifa's view. That is the sounder opinion. And this is exactly how Isbijabi has mentioned it. And said that their opinion is the more sound one. Mahbubi, Nasafi, etc. have also gone with this. Okay, now that's done. There's a last portion that we're going to cover up in this one is, he says, this is from Imam Maidani. Imam Quduri, for him the chapter has ended. But Imam Maidani says, Tatimma al-muhaya'ah, which basically means that when somebody co-owns, when people co-own something, then rather than divide it, can they just go on a turn-by-turn basis? They use it sometimes, these guys use it sometimes. So it's on a sharing, right, platform, a sharing basis. So he says, al-muhaya'atu ja'izatun istihsanan. It shouldn't be, because there's no real division in that. But istihsanan, according to juristic discretion, it should be permissible. وَلَا تَبْتُلُ بِمَوْتِهِمَا. And such an agreement should not even, should not be invalidated by their death, so their inheritors can carry on with that agreement if they want to. They don't have to redo it. Likewise, if one of them died and the other one didn't die, then again it should be able to carry on. وَلَوْ طَلَبَ أَحَدُهُمَا الْقِسْمَ. But as soon as any one of them, because it's been working, you use it, we use it, you use it, we use it, it's been working for years, and then if one of them ever seeks a division, then that agreement will be cancelled, because it was a discretionary, it was only discretionary. The main thing is split it up and just become, get everybody's portion to be independent. وَتَجُوزُ فِي دَارٍ وَاحِدَةٍ. So such an agreement, such an arrangement is allowed even in one house. They do this in holiday sharing, right? Multiple owners, but they're part owners, right? These guys use it for these 2 weeks, these guys use it for these 2 weeks. You have to book in advance, first come, first serve, or it could be just reserved for certain times of the year for these people. And بِأَنْ يَسْكُنَ كُلُّ مِنْهُمَا طَائِفَةً, in the sense that each one of these parties will live in there and occupy it for a certain period of time. Or أَحَدُهُمَا الْعُلْوَ وَالْآخَرَ السُّفْلُ. Or it could be that, okay, you're going to take the bottom half and I'll take the top half. Or you take this side and we take that side. That's also completely fine, although they both own both sides together. وَلَهُ إِجَارَتُهُ وَأَخْذُ وَالَّتِهِ. Now, if I've got my side, that I take the top part or the bottom part or whatever it is, I can share I can let somebody use my share. I can rent out my share and take the income of it, because I'm choosing not to live in there, whereas I could have. So it's completely fine. It doesn't mean that you're not allowed to share it out, or you need the other person's permission or something like that, because as long as I give it to a person who's not going to destroy it, because ultimately it is the other person's property as well. Okay, so وَلَهُ إِجَارَتُهُ, he has a right to rent it out, وَأَخْذُ غَلَّتِهِ, and also take its income. وَتَجُوزُ فِي عَبْدٍ وَاحِدٍ. If somebody shares a slave, is co-shared between them, it's fine. يَخْدِمُ هَذَا يَوْمًا وَهَذَا يَوْمًا. So the way you will do the muhaya, which means the turn by turn share is he'll maybe come and serve this master one day and the other one the next day. Likewise, even if it's in a small room, they own a small room together, they can take turns. وفي العبدين يخدم كل واحد واحدا. When it comes to if they own two slaves together, then don't make it that they have to keep moving. He says, this is at least one opinion, that just give one to one person, give one to the other person. Let them do it. فَإِنْ شَرَطَ طَعَامَ الْعَبْدِ عَلَى مَنْ يَخْدِمُهُ جَازَ. Now somebody has to feed the slave, right? So if they have both made it stipulated that whoever's being served, then they are going to whoever's being served, they have to pay for the food and they have to feed, then that's fine as well. However, they're saying that in terms of clothing, that would not be necessarily fair, because clothing stays a bit longer. So just because his clothing may have torn while he's with me, I have to buy his next set of clothing, and they always tear when they're with me, for example, right? So that might not be fair. وَلَا تَجُوزُ فِي غَلَّةِ عَبْدٍ وَلَا عَبْدَيْنِ. It's saying that if they own slaves and they rent them out for other people to serve, then how do they deal with that? Like one day I'll take the income and the next day I'll take the income, saying that it's not permissible with regards to the income of one or two slaves, nor when it comes to animals, when it comes to fruit trees. Because what could happen is that he may be sick on one day, or when it comes to the fruit trees, in that particular season when it's with me, it bore fruit, on the other one it didn't bear fruit. So you'd rather make it a bit more fair like that. Likewise, you can't do it if it's a shared cow and you're selling the milk. So you'd rather just split it up like that, rather than, okay, one day's milk income is mine, one day, because there may be discrepancy in that and there's just hard feelings in that. Likewise, the offspring. Sometimes you have these pedigree animals, they may be co-owned. Say, okay, this year, whatever offspring come, then they're yours. Otherwise, next year it's mine, and then they may have a bad year. So it's better just to split all of that up. They say it's similar to, for example, if you own a joint car, you ride or I ride. No, just do it together. For example, share the proceeds together, rather than today's income you'll take tomorrow's. Tomorrow I may not get a customer. Okay, so and then next day you have a customer, it's just going to feel really bad. It just makes people feel bad. So just do it as a share, rent it out together and share and the income, right? Likewise, if there is a slave and a house that's co-owned by them, they can have turns in that, as we already talked about in a slave and a house, right? In terms of the sukna and the khidmah, in terms of who's going to stay there and who's going to serve. And likewise, anything that has different types of services, they would have the similar hukum to this. So by that, we have completed the chapter of qismah. And inshallah, we'll be starting with the next one, with a new chapter on Kitab al-Iqra, which I'll discuss next, inshallah. Assalamu alaikum wa rahmatullah. So, alhamdulillah, we managed to finish Kitab al-Qismah. Now, in order to finish this lesson off, we don't have anything more to speak about Qismah, so we're going to discuss Kitab al-Iqra, which is the next section. So I'm going to describe to you what Iqra refers to give you that overview, and then after that, inshallah, we can carry on with what Imam Quduri says about it. So Kitab al-Iqra. Now this is a chapter that deals with Iqra. Iqra refers to coercion or compulsion, when you force somebody to do something. So what position does that hold in the Sharia? Can you force someone? Can somebody be forced? And number two, or more importantly, is that if somebody is forced to undertake a particular transaction or a particular something, what happens? Is that ruling implemented or not? If somebody does something by force, meaning they're coerced to do something, then is that going to be a valid transaction or not? So under duress, what is valid, what is not valid? So Iqra covers a number of situations. When somebody's forced or pressured into doing something against their will. So the key issues would be, we're going to discuss what exactly ikrah is, the definition of it, the types of coercion. There's severe coercion, where the threat is to life or limb. And then there's lighter forms of coercion or pressure, where a person might be put into prison or something of that nature, right? So the legal consequences of actions taken under coercion, such as contracts, if you do a contract under coercion of a sale of something, divorce, or some criminal act, that's not a contract, but if you did a criminal act, then are they valid or invalid? And the impact of coercion on legal and religious responsibility. For example, a person is coerced to say blasphemous statements, apostatize, say bad things or say things about disbelief, or commit disbelief, right? At least verbally. Then what's the hukum of that? Then there's valid and invalid forms of iqra. Some of them do excuse a person, while the others do not excuse because they're not severe enough or something. And then of course the whole point of intention will be covered in there as well. So yeah, we're going to look at a lot of these things, and let's just jump right into it. So he says, Kitab al-Iqra, مناسبته للقسمة أن للقاضي إجبار الممتنع فيهما. Its relationship to qisma, which was just before, they always mention the relationship. Again, this is page 228 of the Bakdash edition of Al-Lubab fi Sharh al-Kitab, so you can follow along if you want to, right, in the book itself. So the reason for its relationship with qisma is that the qadi has this discretion, just like he has discretion to divide and provide a division. Likewise, he has a right to do this as well. And lughatan, literally speaking, it means hamlul insani ala amrin yakrahuhu, to force somebody to do something that they dislike. That's the literal meaning. Whereas the technical meaning is hamlul ghayri ala fi'lin bima ya'dimu ridahu duna ikhtiyarihi lakinnahu qad yufsiduhu wa qad la yufsiduhu. Technical definition. So listen carefully here. Technically, it means to force somebody, compel somebody, pressure somebody to do an act in a way that you are stripping away their choice, meaning they got no choice but to do it, right? Or at least that's what you're pressuring them to do it that way. They don't want to do it, and you're making them do something against their satisfaction, right? However, it might be against their satisfaction and pleasure, but it does not necessarily mean that they are compelled physically to do it. Which means that they could just refuse and act stubborn. They might be killed for it, but so there's a difference between you then finally bowing to that pressure or that compulsion and then doing it with your own choice, or refusing to do it and just being stubborn, not doing it. So one is you do it satisfactorily, or you do it without satisfaction, without wanting to do it, but of course it's yours. So what we're talking about here is not like somebody's hand being taken with a knife in a way that they can't stop themselves and stabbing somebody else with it with their hand. Now, they had no choice in that. The ikhtiyar was lost. So that doesn't come under ikrah. That's a different category. This is saying where they're forcing you to do something against your will, but you end up doing it yourself. You could refuse, but you don't because you're worried about the threat, for example. The different types of ikrah, the different types of compulsion, coercion, the tanqih mentions that وهو إما ملجئ بأن يكون بفوت النفس أو العضو وهذا معدم للرضا مفسد للاختيار. Sometimes it's going to be absolute compulsion in a sense that it's going to be a warning against your life or a limb, and this would obviously take away your satisfaction, and it obviously also corrupts your it's such a serious one that it corrupts. You're making a choice there, because you know, do you have a choice, right? وَإِمَّا غَيْرُ مُلْجِئٍ, or it's not going to be that extreme, it's not going to be that much pressure. بِأَنْ يَكُونَ بِحَبْسٍ أَوْ قَيْدٍ, I mean, that's bad enough, but it's not as bad as the first one. It's just relatively less. So it's not one that puts you into such a desperation that the warning there is that you're going to be imprisoned or you're going to be beaten, but not to the level of, you know, losing a limb or a life, right? This obviously takes away your satisfaction of doing that job, because I mean, come on, you know, why would you want to do that? Why would you want to do what they're telling you to do? They're forcing you to do it, and they have to threaten you for it if you enjoyed it, right? غَيْرُ مُفْسِدٍ لِلْإِخْتِيَارِ. But what it does do is that it does not, you still have more of a choice in that case to refuse, right? والحاصل كما في الدرر أن عدم الرضا معتبر في جميع صور الإكراه، وأصل الاختيار ثابت في جميع صوره، لكن في بعض الصور يفسد الاختيار في بعضها لا يفسده. So the conclusion of all of this is that the compulsion has to be such that it's making you do something you don't want to do. So your approval of that thing is definitely gone, right? You don't want to do it, that's why there's a force, right? So it's in all forms of ikra, in all forms of this compulsion and pressure, right? You lose your satisfaction with something, your wanting to do something. However, you still always maintain a level of ability to actually do it or not, right? You may not want to do it, but or you may feel that you have to do it, but you don't have to if you don't want to, because you can just stay there and not do anything, right? And be killed or be beaten up. That's a choice. So you do have that choice, minimum level. But in some cases, you get more of that choice, meaning you got more scope to use your choice. In some case, you have very less scope to use a choice. Much more serious case, like losing a limb or losing a life. Then the choice is going to be very restricted. It's still a choice, but it's going to be very restricted. That's what he says. Now he says, وَشَرْطُهُ قُدْرَةُ الْمُكْرِهِ عَلَى إِيقَاءِ مَا هَدَّدَ بِهِ. For this to be legally considered to be a force that is legally considered, in a way that, you know, the person who forced, the compeller, can then be punished and so on and so forth. The person better have the ability to carry out what they're threatening you with. If they don't have the ability to carry out what they're threatening you with, and it's also you know that, then obviously that's not compulsion, is it? Because you know that they can't carry it out anyway. وَخَوْفُ الْمُكْرَهِ, number 2. So along with their ability that they've got to see it through, the compelled person must have fear. If he doesn't have any fear, they can do it, he doesn't really care, then obviously that's not going to be a case. And وَامْتِنَاعُهُ عَنْهُ قَبْلَهُ, and also the thing they're telling him to do, like steal something or curse someone or whatever the case is, right? That is something that he should have been abstaining from before. He should not have been a thief. He should not have done that thing before, meaning it's not something that he's used to doing. That just shows that that's wrong. Otherwise, if he's used to doing it, well, it may still be a form of compulsion, but it's not this one. So he says, الإكراه يثبت حكمه إذا حصل ممن يقدر على إيقاء ما تود السلطان كان غيره أو لصا. So that's what we're going to discuss. Bismillahir Rahmanir Rahim. So to finish off today's lesson with the 1 or 2 mas'alas of ikrah, is saying that al-ikrah yuthbitu hukmuhu al-ati idha hasala. So as we were discussing, that the ikrah, the compulsion, its legal effect and ruling only come about if it's taking place and it's occurring, meaning it is the compulsion is coming from somebody who has the ability to essentially carry out what they are warning about, what they're threatening with, whether that be the sultan, the leader, the ruler, or the council, or whoever it is, or another authority, or somebody else, or maybe it's the thief who's doing this, right? Or anybody else. that if you don't open your safe, I'm going to kill you. I'm going to kill your children, whatever it is, right? And you believe that they will do so, right? Because if they are like this, meaning that they do have the ability to carry out, and you know that's usually the case, then it means that the person under compulsion is definitely under compulsion, because he can't do anything else. He's lost his mind in that regard. You know, he wants to save his life or save his children's life or somebody else's life. This is according to the Sahibain. Imam Abu Hanifa says that he doesn't agree with Sultan. He does not agree that it can ever get to this level of extreme threat, except if it's coming from the ruler or the authority, because he reckons that only the authority can do this, only has this ability, right? And nobody else has that kind of authority. Now this is a really interesting point. The rest of the scholars, what they say is that this ikhtilaf, where Sahibain say that it could be from anybody, whereas Imam Abu Hanifa says this will only be a valid form of ikrah if it's coming from the sultan or the authority themselves, because only the sultans have this ability to do that and to carry out what they do. Nobody else has that right. So the scholars have explained is that this is not really a difference of opinion based on evidence, but more based on what they see of their time. Because in Imam Abu Hanifa's time, only the sultan had such power. There was nobody else who had that kind of power to do that, because there was just too much power of the sultan to allow anybody else to go to that level to kill somebody, or to, you know, to threaten to kill somebody and be able to carry out as well. It was just, the authority was just too strong, right? Whereas when it comes to the Sahibain's time, by that time things had become, the authority had become weaker. The authority then, you know, people, gangs, you know, like we have today, gangs and others who have that ability, government can't do much about them, they can't do enough about them. That is what had happened, that they'd become a lot of people, a lot of individual groups and others who could carry out their, carry out their threats like that. So that's why we would say that the fatwa is on the Sahibain's view today, right? Because the government is sometimes constrained to stop all of these kind of cases, and there's lots of gang cases of this nature where they can, you know, extort and so on, right? In some countries, obviously worse than in other countries. So that's the end of today's lesson. Inshallah, we'll carry on with the ikrah in the next lesson. Inshallah, we'll see you then. Assalamu alaikum wa rahmatullahi wa barakatuh.